Hi, good morning. This is Ruby Powers, board-certified immigration attorney with Powers Law Group in Houston, Texas. This is for our weekly update of what's going on in immigration and a theme of some questions that we've been receiving throughout the week or the last few weeks, as well as some updates of some case events that we have with our firm and speeches. So let's get straight to it. Happy Go Texan Day if you're in Houston and you're dressed up for getting ready for rodeo, and it's also Friday, so that's always fun. And it's my daughter's birthday, so there's gonna be a lot of cupcakes and cake in the near future, so it's a good day. What's happened this week? Well, it seems a little bit lighter in the news, but we do have some big things happening here. One of them is that we're still waiting for the Supreme Court to make a decision about the DACA appeal. So remember last year President Trump said no more DACA, and then in January a judge said, oh, you can still file DACA renewals. And so then since then we've been filing DACA renewals, which we weren't able to after October 5th of 2017. And then the White House filed an appeal to that decision, and it's at the Supreme Court right now. The Supreme Court had deliberated last week. We talked about that with the behind-the-scenes discussions, and they were supposed to give us a decision. We don't have a decision. So we don't know if we'll get one today, February 23rd, or we'll get one maybe next week. But for right now, you can still file a DACA renewal if you're otherwise being eligible. And the other thing to let you know is that while we're doing Facebook Live, remember, you can call us at 713-589-2085 or email us at contact@rubypowerslaw.com, or you can ask a question on our Facebook Live. So basically, you can file DACA renewals, and we are waiting to get an update from them any day now. The other thing that's going on that I believe is from yesterday, or that hit the news yesterday, is that the wording of Nation of Immigrants has been removed from the mission statement from USCIS. So the United States Citizenship and Immigration Services informed employees in a letter, the director at USCIS informed in a letter Thursday, so that was yesterday, that its mission statement has been revised to guide us in the years ahead. And gone was the phrase from the described agency as securing America's promise as a nation of immigrants. So that's not a part of the mission anymore, to secure America's promise as a nation of immigrants. Earlier last year, President Trump had made an initiative, Buy American, Hire American, which has been on the slides of USCIS website, and has definitely changed the sentiment of how they adjudicate mini visas, and just a general paradigm shift with immigration, with the government in general. But now, this is a pretty big deal. I mean, words are powerful. This is their mission statement, and they're saying that this is not a part of their priority. The former director of the USCIS from 2014-2017 said that the revision of the mission statement marked a particularly sad turn of history. He also said, we should not forget that under the discarded mission statement, the integrity and the national security functions of USCIS grew dramatically, so showing that we could be both a welcoming nation and a safe one. We should stop to reflect about the many opportunities that America will lose because of the attitudes reflected in this statement, and ask ourselves whether this is really the country we want to be. So, even though this is a mission statement, this is critical, because this helps prove where the mindset is moving. More and more of an anti-immigrant mentality in the United States from the administration's directive. And, like I said, we saw that with the Buy American, Hire American, which wasn't just a slogan, it was also a way of adjudicating, the way of thinking, a way of doing. And now I think that this is even further evidenced by this change in the mission statement. So this was big news in the last 24 hours, and we'll continue to see how this plays out. But you know, the other focus was on legal. They don't consider people customers. We think that they're also going to be less willing to communicate and to give updates and information. And I think that we're going to sort of see how this really plays out in the coming future. And then another news from yesterday was President Trump says that he may pull immigration enforcement from California because he considers it a sanctuary state for immigrants, and that I think his logic is that if he were to withdraw this enforcement, then California would regret it, and because of a matter of public safety. Well, I mean, on the flip side, if he were to do that, then maybe a lot of people would want to move there. So we'll see what happens. I mean, it's a may possibility. Who knows? So that was also in the news. You know, it's not really immigration related, but a lot in the news has been about guns and gun safety, and that has really dominated the public dialogue. And but immigration is undercurrent of what's going on in the public space right now, as well as a reminder to, if you haven't already registered to vote, May 6th is election day, and early voting has started in Harris County and probably around a lot of the United States. So be aware of the voting deadlines. So this week we're going to talk about permanent bars and unlawful presence. And so what is unlawful presence, you may ask? Well, unlawful presence was created under IRA, which was a tough law that was passed in 1996. And it started accruing as of April 1st, 1997. So whenever you don't have a status and or you don't have something pending, generally you will be accruing unlawful presence after April 1st, 1997. So people who are under 18 don't accrue unlawful presence. People who have certain applications pending like asylum or adjustment, things like that, are not accruing unlawful presence. Neither if you have DACA or TPS, you're not accruing unlawful presence while that's valid. So there's actually a long memo about this, so it's sort of hard to explain it all really quickly, but that's like the high-level answer to that question. And unlawful presence is not the same thing as unlawful status. Status is when you have like a visa valid, if you will, up until a certain point. So a person could potentially, basically unlawful status and unlawful presence are not the same thing. So unlawful presence basically was created in April 1st, 1997, and there are some exceptions when you're not accruing it. And the other thing, that is the reason why when someone comes for a consult, I usually ask lots of questions about entries and exits, and if was anything pending, because that's why it matters. Dates matters, time matters.
So the next question is, what is a permanent bar?
Well, a permanent bar, there's different types of permanent bars, but since we're talking about unlawful presence, we're talking about, it's in 212A 9C, and this is basically when, the way to explain it is if a person entered the United States and overstayed for more than a year, and then left, and then came back in, and then leaves again, that person would be permanently barred. And then the other option is when a person who's been removed, tried to come in or was removed, and then attempts to re-enter is inadmissible with a permanent bar. So this is sort of hard to explain without some scenarios, but for example, let's say somebody came into the United States and overstayed for more than 1 year, and then they left the country to go to a funeral of their mom or their dad or something. And then they came back in, and then they got married to an American, and then they were wanting to go through the provisional waiver or something like that. Well, you're not eligible for the provisional waiver because since you had already accrued, and again, let me say, they accrued the 1 year after April 1st, 1997, and they were over 18, let's say. So that's why ages, dates, all of this is really critical. And when people come in and they say, oh, so-and-so did this and did that, and they did this and that, I mean, everything matters depending on what the facts, the exact facts of everybody's case. Because the laws change, the years, the dates, the times, and the factors. So anyway, if someone came in and they're over 18 and it's after April 1st, 1997, they overstayed for more than a year, they left, even if it was for a day, and they came back in, and then they want to figure out everything, the next time they would leave, they would be permanently barred, which really means they would have to stay out for 10 years, and then they could submit a waiver to come back in. They would actually have to stay out for 10 years if they wanted to finish the process. So the other situation would be like if the person came in and they were ordered removed, and then they went back home, and then they got back in illegally, and then they were trying to do consular processing or something like that. Then if they were to leave, again, they would be permanently barred. So bottom line, if you have multiple entries or you have a removal order and you left and came back, then you're probably in that permanent bar space. But it's always important to have a consultation with an experienced immigration attorney because, like I said, we can know the law and the facts, but we have to talk to each individual person to see whether they'd be permanently barred. And along this whole discussion, basically, if you go to consultation or you're talking to an attorney, you need to tell the truth because the government knows a lot more than you think they know. And with all their increased synchronization of their databases and vetting centers and etc., there might be a lot more that the government knows that you don't know. So whenever anybody says, oh, nobody knows I left the country, I say, well, that I know and you did, and we can't do it like that. So because unfortunately there are many times when people come to me with their loved one is stuck not in the United States but they're in a foreign country with a permanent bar because for some reason there was a miscommunication or misunderstanding, or and the person is having to stay outside of the country. So please be aware of those things before you proceed. That's why it's really important to have an experienced immigration attorney help you.
How is the length of the permanent bar determined?
Okay, well, let's go back just a little bit and talk about the 3 and 10 year bar for unlawful presence. So again, remember I said 1997, April 1st is when unlawful presence was, I guess, invented, or if you will, began. And so if a person was unlawfully present from under 6 months and they leave the country, there's no bar. If a person is in the United States more than 6 months but under a year and they leave, then they will have the 3-year bar. If a person is here over 1 year and they leave, they will have the 10-year bar. And then if they've done what I said a little bit earlier, they came, overstayed for more than 1 year, left, came back in, and then want to leave again, that's a permanent bar. So there's the 3, 10, and permanent year, and the permanent bar that you have to be concerned about. And we're just talking about unlawful presence. There's other bars from removal orders and expedited removals and things like that as well.
So is this bar truly permanent, or are there other ways around it?
Well, the unlawful presence permanent bar, I've had about 3 or 4 clients actually wait the whole 10 years outside the country. So again, if they came in the United States and overstayed for more than a year, left, came back in, and then left again, for example, that client stayed out the country 10 years, And then when their 10-year anniversary of being outside the country was almost over, we submitted the I-212 and the I-601 waiver to be able to come back into the United States. And then they were, well, it depends on the waivers needed, depending on the facts of the case, if there was any other complications. But then they were able to come back in. But again, if April 1st, 1997 is that's like 20 years ago, some people might not have had the time to wait the whole 10 years. Or maybe they didn't want to wait the whole 10 years. So you don't see that situation that often, but we might still see it more. And in terms of advocacy and changes of law, this is definitely a very difficult provision that makes it very complicated for people. And like, since many people cannot adjust or change their paperwork in the United States if they don't meet certain exceptions, and then if they were to leave, they'd have the permanent bar. A lot of people get stuck in this situation after the creation of unlawful presence and all these bars.
Do I need an attorney to help me with a provisional waiver in order to avoid the permanent bar? And if so, is this something that Powers Law Group can help with?
Okay, well, generally the provisional waiver is not going to solve a permanent bar. The provisional waiver is only for very clean unlawful presence issues. And it's generally for a person who's entered one time illegally, and they've in the United States now, and they have a qualifying relative and the waiver, and they leave the country, and then they are reviewed at the consulate to come back in. I would not want, if I know that a person's going to have the permanent bar, they're not eligible for the provisional waiver. So they shouldn't apply for the provisional waiver, and they shouldn't leave the country. So back to, can the Powers Law Group help you on these things? Yes. I mean, I think the most important thing is to have your case screened well. Because I actually spoke at South Texas College of Law Houston this week, and we were talking about waivers and inadmissibility. And I basically said one of the most challenging parts is being able to screen a person to find out what their inadmissibilities and what they're eligible for. So I said the first step is to screen for inadmissibilities, and that is what an experienced immigration attorney can do. Someone who's seen a lot of different cases over a long period of time. The attorneys here at Powers Law Group have had 10 years or more of experience, each attorney right now, and we'd be able to screen and ask lots of probing questions about that to help ascertain if a person's eligible or not. The other thing to consider is that a person, maybe they do have an inadmissibility, but we have to figure out if there's a waiver for it and if there's a qualifying relative. So in general, we have a lot of experience with that. We have a legal system that does almost only waivers right now, and we speak regularly on waivers and admissibility. And having done this on a regular basis for 10 years, we've been able to help people and avoid people from getting stuck outside the country with a permanent bar.
If I want to apply for asylum or I'm seeking refuge, am I still held to the same conditions of the permanent bars?
Well, for unlawful presence purposes, the asylum, it's not really the same situation, because in many cases, a person who's applying for asylum, well, they're inside. For asylum purposes, they're inside the country already. And refugee, they might not have ever come to the United States yet. So unlawful, while the asylum application is pending with the affirmative, with the asylum office and in court, you're not accruing unlawful presence. And generally, if a person enters the United States, they will have to apply within 1 year for asylum, with some exceptions. So if a person was still in status at the time they applied for asylum, they may never have accrued unlawful presence. So that doesn't become an issue. And it doesn't keep you from being able to adjust later on. So the other aspect might be if the person entered, overstayed, and then applied for asylum within the year, or maybe they meet one of those exceptions. They might have accrued unlawful presence, but it really doesn't come into being an issue unless you lose your asylum case and leave the country and then trigger a bar. Otherwise, if you win your asylum case, then you'd be able to stay in the United States, and then later on, after a year, meeting all the qualifications, apply for legal permanent residency. So that is the last question that we have for right now. Again, we take questions all week long at our 713-589-2085 number, or the email that we have listed here, as well as on our Facebook Live. You can post questions. Just before we conclude, we have some updates of some things that are coming up. On Monday, February 26th, I'll be speaking on the topic of perfecting your successful asylum case for attorneys. That'll be a CLE that I'll be presenting for lawline.com. And that is, and then also on February 27th, I'll be presenting at a community center in New Jersey. You can contact the office if you are interested in learning more about that. On March 7th, we will have, I will do the provisional waiver webinar at 9 a.m. and that's the I-601A provisional waiver. So we can that's free. We can take questions. If you have, you can ask questions, and we're not charging, and you can ask questions throughout the webinar, and I'll be going over like scenarios and how to screen and what you need to do a successful provisional waiver. I will be traveling actually next week to New Jersey for an asylum interview, and I'll be while I'm there, I'll be doing some different presentations on Monday and Tuesday. So you can contact us to find out more details about where I'll be. That will be on February 26th and February 27th, in the New Jersey, New York area. And then on March 8th, we have a presentation at Hicks Elementary School in the Houston area. And on March 18th, and all these things are listed on our Powers Law Group, rubypowerslaw.com website under the Events tab. And we'll keep that updated on a regular basis. As well, we have the newsletter that goes out every other week. Went out this week in English and Spanish, and we keep you updated on those things. And again, if you want one of us attorneys to come speak to your group, we've been reached out by some different groups right now. Please give us a call. Community groups, schools, corporate business groups, we will do that as well. Give us a call at 713-589-2085. And one last thing, we will be at the Nowruz festival, spring festival, on March 18th. So that's going to be the second weekend of spring break. We will be having a booth there, and that's going to have like folk dancing, food, play area, face painting, and things like that. That's at Levy Park from 10 a.m. to 9 p.m. And there'll be a lot of different countries represented, from Turkmenistan, Tajikistan, Turkey, Uzbekistan, Azerbaijan, Bosnia, Kazakhstan, and Kyrgyzstan. And we have clients from most of these countries. And so I'm looking forward to going to that. Hopefully we have good weather, but I think they're going to have a tent anyway that will be in a table there. So I think that's it. So have a great week. Have a great weekend. Be safe. And thanks for listening. This is Ruby Powers with Powers Law Group. Take care.